Welcome to our deep dive on protecting inheritances and gifts. First, we will frame the problem many generous people face: trying to help younger relatives without creating tax headaches or legal risks. Next, we will unpack the tax reality of inherited IRAs, especially how required distributions become taxable income. Then, we will discuss why direct gifts to young adults or minors are risky, and how to avoid those pitfalls. After that, we will compare protective structures, like trusts and UTMA accounts. Finally, we will walk through a step-by-step plan to implement proper legal shields with professional guidance, and we will finish with key takeaways and a call to action. Before we begin, here is our roadmap. First, we highlight the problem. Then, we cover taxes on inherited IRA distributions. Next, we examine why direct gifting is dangerous, especially with young beneficiaries or complicated family dynamics. Afterward, we compare trusts and UTMA accounts. Then, we guide you through a step-by-step setup. Furthermore, we will use diagrams and quick quizzes to reinforce learning. Lastly, we will summarize with an action plan. Before we proceed, please note this content is educational and not legal, tax, or investment advice. Because laws and individual circumstances differ widely, you should consult a qualified trust and estate attorney and a tax professional before taking any action. Now let's frame the problem. Many people receive significant assets, such as inherited IRA funds, and feel compelled by moral commitments to gift money to young relatives. However, without a plan, good intentions collide with tax consequences and legal risks. Consequently, a simple transfer can become a long-term liability for both the giver and the recipient. Let's talk taxes. Inherited IRA distributions generally count as ordinary income to you, the recipient. Therefore, taking a large distribution in a single year can push you into a higher tax bracket. To mitigate this, many people plan multi-year withdrawals that coordinate with other income sources and deductions. Additionally, inherited IRA rules and required distribution schedules can vary based on factors such as your relationship to the original account owner and the timing of their passing. Because these rules are complex and evolving, you should work with a tax professional to build a compliant, multi-year plan tailored to your situation. Here is a timeline illustrating a 5-year example strategy. First, in year 1, a smaller withdrawal helps avoid an immediate bracket spike. Next, in years 2 and 3, moderate distributions align with periods of lower other income. Then, in year 4, if income is elevated, you might reduce the withdrawal. Finally, in year 5, you finish the plan with any remaining distribution. Throughout, the key is coordination with a tax professional, monitoring adjusted gross income thresholds, and considering charitable strategies where available and appropriate. Direct gifting seems simple but can backfire. First, you lose control over how funds are spent, which is especially problematic with young adults. Next, funds routed through an estranged parent for a minor can be diverted, misused, or contested. Furthermore, if you manage money informally for others, you may create personal liability. Without formal structures, there are no maturity safeguards, such as staged access at 21 or 25, and poor documentation increases the risk of disputes. Consequently, professionals advise against direct gifts in sensitive family situations. Let's compare structures. A trust is highly customizable. You can set access ages, explicitly bypass parents or guardians in decision-making, appoint a professional trustee, and include asset protection provisions and clear instructions for education, health, and maintenance. In contrast, a UTMA account is simpler and often cheaper to set up, with a custodian managing funds until the statutory age. However, it transfers automatically at the age of majority and offers less flexibility and protection than a trust. In many cases, a UTMA is still superior to direct gifting, but a trust provides the strongest control and shielding. This decision flowchart guides you based on age, family dynamics, and control needs. If the beneficiary is under 18 and an estranged parent is involved, a trust with an independent trustee is recommended to bypass parental control. If there is no estranged parent and the amount is modest, a UTMA may suffice, though a trust can still be preferable for larger or complex situations. For ages 18 to 24, if spending control is needed, Use a trust with age-based milestones. If the young adult is very responsible and the amount is small, a UTMA or supervised support may work, but avoid direct cash. For beneficiaries 25 and older with strong financial maturity, a trust is optional, and a lump sum with proper documentation may be appropriate. Throughout, consider the size of the gift, family conflict, and your potential legal liability. Here is the step-by-step setup. First, hire a qualified trust and estate attorney. Next, define your beneficiaries' goals and targeted maturity ages for access. Then, select a trustee and articulate their powers and responsibilities. Afterward, draft the trust with clear distribution standards for health, education, maintenance, and support. Meanwhile, coordinate with your IRA custodian and a tax professional to plan compliant withdrawals. Then, fund the trust properly and document your intent and communications. Finally, review the plan annually and update it as laws or family circumstances evolve. This table illustrates how timing affects taxes. First, consider a baseline income of $90,000. Next, if you add a $60,000 inherited IRA distribution in a single year, your total income rises, potentially pushing you into a higher marginal bracket and increasing total tax. Alternatively, if you split the same $60,000 over 3 years, the annual tax impact may be more manageable. These numbers are simplified and for illustrative purposes only. Actual tax results depend on your filing status, deductions, credits, state taxes, and the specific inherited IRA rules that apply to you. Consult a tax professional for personalized planning. Use this checklist when designing your trust. First, define your primary and contingent beneficiaries. Next, set age-based milestones and any emergency access rules. Then, choose an appropriate trustee structure. After that, draft clear distribution standards, often summarized as health, education, maintenance, and support. Furthermore, include protective provisions such as spendthrift clauses and creditor protections to reduce exposure to claims or divorce. Additionally, define how assets will be managed and rebalanced. Finally, document your intent and communicate thoughtfully with the trustee and relevant family members. This sequence diagram shows the operational flow. First, you consult the attorney. Next, the attorney drafts the trust. Then, you coordinate with the IRA custodian for distributions payable to the trust. The trustee receives the funds and invests according to the trust's investment policy. When the beneficiary requests a distribution, the trustee evaluates the request under the health, education, maintenance, and support standard. If approved, the trustee disperses funds to the beneficiary. Finally, the plan undergoes annual review and reporting to ensure ongoing compliance and alignment with your goals. Question: in a sensitive family situation with a 14-year-old beneficiary and an estranged parent, what is the most protective approach for gifting? Options: 1. Send cash to the estranged parent and trust they pass it along. 2. Put funds directly in the child's personal bank account. 3. Establish a formal trust with an independent trustee and clear terms. 4. Skip documentation and rely on an informal promise. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is to establish a formal trust with an independent trustee and clear terms. This structure bypasses parental control, provides oversight, and enables age-based or purpose-based distributions to protect the assets. Question: after inheriting an IRA and wanting to help young heirs, which actions are prudent first steps? Options: 1. Consult a trust and estate attorney. 2. Plan multi-year withdrawals with a tax professional. 3. Wire the full amount immediately to avoid paperwork. 4. Both A and B. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is both A and B. You should consult a trust and estate attorney to establish proper legal structures and work with a tax professional to design a multi-year withdrawal plan that manages taxable income. Here are the key takeaways. First, inherited IRA distributions are taxable, so plan multi-year withdrawals. Next, avoid direct gifts to young beneficiaries and use protective structures. A well-drafted trust provides the strongest control and protection with maturity-based access. UTMA may be suitable for simpler cases, but offers fewer safeguards. Additionally, working with both a trust and estate attorney and a tax professional improves outcomes. Finally, document your intent and review the plan annually. To conclude, generous intentions must be paired with legal and tax strategies to prevent unintended harm. Trusts can bypass problematic parents or guardians and enforce maturity-based access, while coordinated multi-year distributions can reduce tax spikes. As a final reminder, consult qualified professionals before taking any action so that your plan is compliant and aligned with your goals. Thank you for watching. If this video helped, please like, share, and subscribe. In the comments, let us know your biggest estate planning question so we can cover it in future videos.